provided her with a copy in advance. It's an unpublished opinion, and the only reason I'm giving it to you is it's the exact issues that I'm raising on the scoring of the OB.
All right, you have an argument as to the guidelines.
Yes, Your Honor. With respect to the PRVs, which is 20 points, there's no argument with respect to that. With respect to OB4 psychological damage to the victim, the defense counsel's position is that it's 0, and I did originally split it as 0. So I'm going to let defense counsel make his argument.
OB4, as I provided both Ms. Vertoff from the Attorney General's office and the court, I gave him a most recent case. I just pulled out instead of pulling out a number of cases. This is July 14, 2016. Unpublished opinion of the Court of Appeals, People v. Edmonds, citing the U.S. Supreme Court decision, Alleyne, A-L-L-E-Y-N-E, U.S. Supreme Court of 2013 in Lockridge. This case deals specifically with the scoring of the guidelines relating to the variables OB4, 10, 12, and 13, which are all going to be at issue here. In this case, we pled guilty to 1 count of possession of child porn using a computer in that capacity, and then the third count was taking pictures of an unclothed individual. That's all that he admitted to. There was no admission that there was any psychological injury to the victim. The jury wasn't a case for a jury. As the Court of Appeals cites here, since the defendant did not admit that the victim suffered any bodily injury, or they exploited the victim or abused his authority status or penetrated the victim because none of these factors are necessary elements of the offense, and that since the defendant did not admit to those things, they score those guidelines at 0. And the case was remanded for sentencing. So I believe that OB4, based on what was pled to, is 0. I believe that OB10, which is...
so can I ask, so what you're saying is if you have a victim, and there is one in this map.
Yes, Your Honor.
So if a victim says that I was psychologically harmed, what you're arguing is that because there's no jury trial, I can't judicially take notice that the victim, and in any case, I can't take notice of a victim coming up and making a statement, or making a statement to MDOC saying that they were harmed?
Well, I don't believe, I mean, that's what
because that would mean that would mean no, that means that OB4 in any case against a person will ever be scored.
Well, unless it's in a plea bargain, unless I agree to it or the defendant states it at the time of the plea, I believe that would be correct. But if you're finding...
Do you think that that was the intent of that case, is that psychological harm, unless there's a jury, that psychological harm is never scored?
That's what they did in this case.
So that would mean that a victim would have no incentive to agree to not having the trial go forward, because then they wouldn't actually be heard.
Well, Your Honor, in this case, OB4 scores 10 points of serious psychological injury requiring professional treatment occurred to a victim.
Well, it also, well, if you're going to go down there, it also says score 10 points if victim's serious psychological injury may require professional treatment. The fact that the treatment has not been sought is not conclusive.
I'm just telling you what the case cites here.
Well, if you're going to go down that road, you're citing an unpublished opinion.
I'm citing an unpublished opinion based upon Lockridge.
I'm familiar with Lockridge. I'm sure you know who the judge was in that case.
And Alleyne, which is a U.S. Supreme Court case which is published. And this is, well, I'm not citing this to the Court of Appeals. I'm citing it on issue for the exact scoring of the variables in a lower court. In this case, the Court of Appeals says that the scoring guidelines were remanded back because they should be at 0. The judge in Lockridge, as you're aware, can't judicially fact-find at sentencing.
Right.
And in this case, there's no record of anything being admitted by my client about a psychological injury. It would be fact-finding after the plea. If the defendant had pled at sentencing and agreed that there was psychological injury to OB to the victim, then I believe that the court could consider that for sentencing purposes.
Your Honor, could I just narrow the issue for one second?
That'd be great.
Okay. I don't think that argument is correct, but with respect to OB4, the reason I didn't score it is when I spoke to the victim, she certainly seemed irritated, but not maybe necessarily in need of psychological treatment, and I am usually judicious in my use of OV4.
Is she here today?
She's not. I asked her, and she did not wish to appear. Okay. So a lot of my CSC cases, I do score. In all of my CSC cases, I score OV4, but that I made a judgment call. I didn't score that.
All right. Well, considering what her specific statement is here,
yes,
I will not score it. All right. So that's OV4. What's the next one?
OV10, that he exploited a domicile relationship. He took the camera, was in the bathroom, that is true, but she lives with her father. She visited her mother. She stayed there on occasion. I don't believe that he exploited the domicile relationship.
Okay, let's make this crystal clear. Is he going to deny? You're saying the camera's in the bathroom, and I will say on the record what I said at the bench. I was not made aware of the various circumstances, and I can now say facts unless you want to dispute them. At no point was I told that, and in your client's statement was actually, I captured video of a friend's 21-year-old daughter, actually she was 20, but I captured video of a friend's 21-year-old daughter on a digital camera while testing the camera and did not have her permission. That's the first thing that caught my eye. I'm thinking, all right, how does he test without and capturing her image? And then what he actually did was he had a mini video camera disguised as a clock and stated when he moved into Parsons, when he moved into his girlfriend's home, put it in the bathroom, telling her that it would be helpful for them to make sure they were not late in the morning when getting ready for work. That's not testing a camera. That's not letting anyone know there's a camera. That's putting a clock, what appears to be a clock, which is really a camera, in a bathroom. So we've got pictures of this young woman coming in and out of the shower. That's a little bit different than just a camera. It was hidden from her. She didn't understand what's going on. If that is taking advantage of a domicile situation. Whether or not she lived there, she clearly was showering there at some point. She was clearly visiting her mother at some point. He hid a camera in the guise of a clock. That's scored appropriately. What's the next one? Unless none of that's true.
I'm not admitting any of that.
I think you need to have a trial then. You're going to say that the clock,
What you're going to, Your Honor, was that he took photos of an unclothed individual. What they knew, when they knew it, why
he took photos of an unclothed individual in the bathroom of another person's home, correct?
In the home he was living in, that is correct.
Okay, great. It's scored appropriately. Next one.
So OV13, there's not 3 crimes against a person here. And there's not 3 crimes against property. It should be scored as 0. 2 crimes against a person and 1 against public order.
Okay.
The crimes that he pled to are 2 crimes against a person and 1 crime against public order. There are uncharged crimes of him downloading child sexually abusive materials. However, I'm sure defense counsel's argument is going to be he didn't allocate to those, and there was not a preliminary exam with respect to the child sexually abusive materials. So for the charged offenses, defense counsel is correct in that it is 2 crimes against a person and 1 crime against public order. Oddly, taking photos of an unclothed person or recording an unclothed person is a crime against public order.
Your Honor, there's counts 1 through 5, possession of child sexual abusive material, which are person crimes 1 through 5. In the instructions, it says all crimes within a 5-year period, including the sentencing offense, must be counted without regard to whether the offense resulted in a conviction. There's 5 charges, person crimes. Whether they struck a deal to dismiss some of these counts, it doesn't negate that there are 5 person crimes here. I think it's properly scored.
Again, the Court of Appeals dealt with that direct issue in the case that I handed to you July 26th of this year. The proper scoring under those circumstances when there's no allocution to those offenses pursuant to the U.S. Supreme Court. The scoring is 0.
Okay. I think it's scored appropriately. So now we're at 40 points. Does that change the guidelines?
It does, Your Honor. That means the guidelines go from 0 to 17 to 5 to 23.
Okay. All right. Anything else?
Well, I think it depends.
Now, I'm sorry. Can I discuss the last issue I brought up at the bench?
Yes.
Was there a plea bargain? Because this was not, let me make it clear. Again, not my bargain. Bargain between the Attorney General's office and the defense counsel. Was there a bargain that not only did you drop charges, but that you specifically said you would agree that he only gets county time?
No, Your Honor. The Attorney General's office does not do sentence agreement. What I said is that his scoring guidelines were 0 to 17. It is not normally a prison offense, and that it would be within your discretion, that we would not specifically demand an MDOC sentence, that it would be within your discretion. The defense attorney understands how it works. It's always within your discretion, Judge. If you scored out at 0 to 17, under most circumstances, that should not result in MDOC time. However, the guidelines are merely, we don't have to follow those now.
Guidelines are 10 to 23, not 5.
Thank you. 10 to 23.
If, obviously, if the defendant wishes to withdraw his plea based on all circumstances, we're certainly ready to proceed to trial.
Okay.
Because this guideline scoring is no different than he's convicted at trial. So, yeah, I believe we will do trial.
Excellent.
Thank you.
All right. Does that mean you're reinstating all charges?
Yes, Your Honor.
Okay, so now you're reinstating all 13 charges?
Yes, Your Honor.
Okay.
The guidelines won't change on the sentencing. You might change what you sentence them to, but there's no benefit. That was the
Well, here's
discussion we had.
here's the benefit, obviously, and I've said this before. The benefit of pleading is that even the limited information I have, which is more than I had at the time of the plea, is still limited. I've always said this. I think it is error for a judge to promise anything. And I think it's especially error for a judge, if not unethical, immoral, and completely wrong, for a judge to ever say, if you don't plea, I'm going to hammer you, making me go through a trial. Because every defendant has a right to a trial, whether by bench or by jury, and I believe in that completely. The difference is, I've said, is the information that a judge gets between sitting through a trial and being given limited information in a PSI. That's a significant difference. That's, I would think, if there's a risk to be taken in taking a plea or going to trial, is I am given, as a judge, much more information, and I hear from victims, and I hear much more testimony than I would ever have. And then we also have the whole fact-finding issue that right now you get to argue that I'm not allowed to take notice of, but then would come out.
But you did. You did take notice of them all. So
well, I took away the psychological. Counsel, you have a problem with, not a problem, you have a habit of talking over me. Let me just finish my sentence. I took away the psychological because of the statement was kind of ambiguous in the PSI. Whatever else conviction or a charge has nothing to do with judicial notice. That it is what it is. So what was the last one?
Well, Judge, we just...
Oh, and the domicile. So now you're going to say that you're saying that he didn't hide a clock, which was really a camera, in the bathroom of his girlfriend's home.
I'm saying that you determined that he's exploited a domicile relationship that wasn't part of the plea. He took pictures of an unclothed individual. That was what was put on the record. And when we did the plea on the record, I stood up at the court bench. We did this off the record, and I said, at the time, if he's going to be sent to prison, there is no benefit to him pleading because the guidelines are what the guidelines are.
That's fine, but there's also...
And when we came back, well, Judge,
No, you go ahead. No, go ahead.
When I came back, we thought, I'll speak for myself.
Sure.
I thought that it was a Cobb's agreement, but when it went on the record, you said, you guys killabreed this. And the Attorney General said yes. And at that point in time, I was fine with it, as long as the deal was he was going to get a sentence that was going to be determined by the court, but it wouldn't be prison. And we did this after much contemplation. This wasn't one day of discussions between myself and the Attorney General. They spoke to the victims. They went over the case. We had lengthy discussions about what was my client needs done. They were getting their oversight. They were getting all their convictions on each of the offenses that they had. But if he didn't go to prison, that was the one thing that dangled that he had requested. He wants to get treatment. He's admitted to the offenses. There's definitely, whether the court thinks the PTSD, which I'm unaware of any letters sent regarding that, is being used as a crutch or not. He tried to commit suicide when she was taken into custody. He has mental health issues that need to be addressed. Sending him to prison, I don't believe, accomplishes anything in this case. He definitely needs a punishment. He definitely needs treatment.
I'm sorry, are you arguing for the sentence now, or are you arguing, or do you want a trial?
I'm putting on the record why we made the deal we made. This wasn't something that was done that we were trying to hoodwink Your Honor or pull a fast one here.
I don't think anyone was trying to hoodwink me, because that's what I made it clear. It was the deal that you all struck.
Your Honor, if I may speak, you did say at the end of that, that means you don't have to follow that. It's within your discretion. Do you understand that? And the defendant agreed that he did in fact understand that.
So then what's the basis of withdrawing?
I guess I don't understand.
The Killebrew agreement, that if you don't abide by it, when you got the pre-sentence report.
Killebrew is something that the feds do. The Attorney General's office does not engage in a Killebrew.
People v. Killebrew is a state case. It's not a federal case.
Well,
The federal case is Castigar, and that's the agreement you do with the U.S. Attorney General.
There's no sentence agreement. Just to be clear, we agreed on the guidelines.
When the judge gets a pre-sentence report and you don't agree with the agreement of the attorneys, you don't have to abide by it. He can withdraw his plea, and that's what we're doing here.
That I completely disagree as to the state of the law.
It was a Killebrew agreement. She agreed that they would not seek prison. If we're going to get prison sentence on this thing, then he gets to withdraw his plea.
But if the Attorney General, that's just it. But okay, thank you for clarifying. she's not seeking prison. I'm saying I am taking the opportunity, based on what you all say here. You've got a lot of time left. I'm just saying, if anyone is coming in, you're saying for sure you're only getting county time. Don't put your hat on that.
Well, that was our belief.
Well, that may have been your belief, but there's a difference between the Attorney General not taking prison time and I'm agreeing not to prison time. I didn't agree to anything.
And I agree. And
okay.
If you don't agree to the deal, she's saying she didn't make the deal. And I'm saying that I believe there was a deal. And if the deal is that he can go to prison, that wasn't what he pled on.
Maybe you should convince me why I shouldn't go to prison. And oh, by the way, counsel, even if the guidelines were 0 to 17, that still could be a prison sentence. Under Lockridge, there is no such thing as guidelines anymore. I just have to make sure that the case is set as to why I am giving the sentence I am giving. They are merely advisory in nature.
I agree. And when it gets remanded back and it's 0 to 11, it would have been 0 to 11. That's the way I pled. That's the way I did it.
If it was 0 to 11, under Lockridge, I could still give him a prison sentence.
I agree. And that's why we made aware, that's why I believe the deal was, and he believed at the time he made the plea, that the deal was he would be sentenced at your discretion up to 12 months in jail.
So do you want to be able to make an argument to me as to why I should get county time, or do you want to just, or are you withdrawing the plea?
Your Honor, if we have 2 minutes in
sure.
the hall.
Go ahead. You want to go in that hall, though? I would advise you.
Yeah.
Okay. You're right. I call another thing.